को इंट्रोड्यूस कर देंगे, बता देना ना आपने जो। हाँ, वो कर दूंगा फिर। मैं पहले तो समझा तो मैंने कहा शायद आप कर रहे या कोई मैडम कर रही है।
Okay, sir, I'll introduce, sir, not an issue.
प्लीज प्लीज।
Yes. So we are just waiting for Rajat sir to join. He's joining in a minute, sir.
प्लीज प्लीज, नो प्रॉब्लम।
Thank you for the patience. Thank you. Yes. Vikas, you can also turn on your camera now. Yeah, so we are just waiting for Rajat sir to join. He'll be joining in a minute.
Firdaus, I think we should start, and Rajat will be joining in the meanwhile.
Yes, sir. Okay. Yeah. So, good afternoon, everyone. It's my pleasure again to welcome Shri Pradeep Sambil ji, Shri Arun Bhargav sir, and Shri Rajat Panda sir. So, Vikas, today you have a 3-panel interview with this esteemed panel. Our first panelist for today is Pradeep Sambil ji. Sir has done private practice in district court for about 5 years, and thereafter he has served as public prosecutor in Himachal Pradesh, and then he joined HP Judicial Services and retired as district and session judge in the year 2020. Welcome, sir.
Thank you, madam. Thank you.
Our second panelist for today is Rajat Panda. Sir has completed his LLB and LLM from NUJS. After that, he cleared Orissa Judicial Services in the year 2016 in his first attempt, and he served as a civil judge in various districts of Orissa for a period of 6 years before taking a voluntary retirement in the year 2022. And afterward, he started his career as an advocate in Orissa High Court and various other courts throughout the country. He is presently working as an educator at LawSikho, and he's also an internal panel, apart from being an advocate too. Welcome, sir.
Thank you.
Third panelist for today is Shri Arun Bhargav. I don't think he needs an introduction, but still I'll give a small introduction. He's an expert faculty with us and also experienced in taking HP interviews and HP Judicial Service coaching. Welcome, sir.
Thank you, Firdaus.
So the line of action will be same with Shri Pradeep sir starting first, then Shri Rajat Panda, and then Shri Arun Bhargav. So, sir, over to you.
Please, thank you.
Vikas, you may please unmute your speaker.
Okay, because now you are from Himachal.
Yes, sir.
And after going through your biodata, you had done your BLLB from Punjab University and thereafter LLB.
Yes, sir.
Have you done some practice, private practice as a lawyer or not?
No, sir. So I haven't practiced as a lawyer after my graduation.
Okay. Thereafter, you presently you are working as a civil judge.
Yes, sir.
You have been selected in MP, Madhya Pradesh.
Yes, sir.
Judiciary. So still your training has commenced or yet to commence?
Yes, sir. So training has been commenced. I have joined on 4th of October 2023, and sir, now it has been around 1 month of training.
You have completed your LLM in which year?
Sir,
Because,
I have.
Please.
Sir, in 2021, sir, I am pursuing my LLM, and sir, in 2022, sir, I have completed, but I have yet to submit the dissertation.
Okay. You had no interest in doing private practice or to do private practice as a lawyer?
Sir, pursuing a lawyer in litigation is a noble profession, but I have always aimed and dreamt of becoming a judicial officer.
Okay. then you have already become judicial officer. Then what prompted you to again appear before the FP Judicial Services, and now you are appearing? You will be appearing in the interview. So what prompted you? In fact, what are the reasons which persuaded you to go for FP Judicial Service?
Sir, actually, I have always aimed to become a judge in the Himachal Pradesh. But
In
sir,
your own state,
yes, sir. Sir, but nowadays the competition of judicial service examination are very high. So when I graduated in 2021, there were no vacancies notified for Himachal Pradesh Judiciary. So, sir, I thought that if I apply in other state judicial services, it will definitely give me an edge when I apply here back in Himachal. So that's the reason, sir, I applied in other states, sir.
So actually, exactly once you had joined, you had put in joined put your joining there
On sir 4th of October 2023, sir, for last month.
October. Oh, just 1 month. Okay. So because since this is a practical, you will be dealing with you will be applying the law rather.
Yes, sir.
In the universities and in the colleges, we theoretically go through the law.
Yes, sir.
But as a judge, you will be applying the law to the facts and the disputes before you.
Yes, sir.
So I suppose that you have gone through naturally. You being while in your LLB, you must have gone through the civil procedure court.
Yes, sir.
So as a judge, one of the sections which is very important from the point of view of service of the parties, services of the witnesses. And you well know that Order 5 is the relevant provision of CPC.
Yes, sir.
So, may I ask you as to what is the requirement when you issue a summons to the opposite party in a civil case? What I am saying is, my query, civil case, you are issuing summons in a suit to the opposite party, to the defendant. Let's be very clear. Defendant or defendants. What are the basic requirements which presiding officer is required to see that this provision of the relevant section, the order has rule has been complied with?
Sir, when a plaint is duly instituted, after that, sir, under Order 5, it is required to issue the service of someone to the defendant to appear and file a reply within 30 days from the issue of summons. As a written statement has to be filed by the defendant under Order 5, sir.
No. You have jumped. You have jumped. I'm asking you a very specific question. When you will be issuing the summons,
Yes, sir.
at the stage of the summons, barring the summons, since you have not done any private practice,
Yes,
and
sir.
still you are in the beginning of your career, I will.
Yes, sir.
I would apprise you that one summon is accompanied by a copy thereof.
Yes, sir.
Okay.
Yes, sir.
What else is required to be sent? I'm giving you a hint, rather.
Sir, along with someone, there must be a copy of plaint. Then, sorry, sir, I'm unable to recall it right now.
Okay, no problem. In fact, it is. I would also give you the answer side by side. It is mandatory to make a lawful service. If you are sending the summons to a party, it is required to be accompanied by a copy of the plaint.
Yes,
And
sir.
if not other documents, then complaint. If you are not sending it, and then you are proceeding ahead. And in the meantime, other party takes objection. The service could not be held to be a valid one. It is the law. It is the law of the our own honorable High Court
Okay, sir.
that it has to be accompanied by a claim
Yes, sir.
and the copy of the application if any.
Yes, sir.
Okay. Now you being judge is required to decide an application under Order 39 Rule 1 and 2 of CPC.
Yes, sir.
My questions will be in two questions. In fact, I'm putting to you in this.
Yes, sir.
First of all, what is the requirement to issue ad interim injunction order against the opposition party? In other words, while passing ad interim injunction order against the party, what you would see as to what is the requirement, whether you have fulfilled the necessary requirement, what are the necessary ingredients to issue an interim injunction against the party who has not the for you.
Sir, first of all, when deciding an application under Order 39, Rule 1 and 2, it is to be seen that there are three tests basically given by the Honorable Supreme Court, which has to be kept in mind before giving the relief of interim injunction. First is, sir, there must be a prima facie case against the prima facie case in the favor of the plaintiff. Second, sir, there must be a balance of convenience in interest of the plaintiff. Third, if the relief is not given, then irreparable injury or loss will be caused to the plaintiff. By keeping all these three tests in the mind, application for interim injunction has to be decided.
What do you understand by prima facie case? What do you mean by prima facie case?
So by pursuit of the record of the case application, it seems to the court that the decision will be given in the favor of the plaintiff prima facie.
In Himachal, if you are coming, going to compete for the post here.
Yes, sir.
If an application is filed under Order 39 Rule 1 and 2 of CPC, seeking injunction in respect of a property, immoral property, and the application is not accompanied by the necessary, copy of Jamabandi.
Okay,
what will you be doing? And if your answer is that you will not be passing any order, then the reasons therefore.
Sir, first of all, I can.
Oh yeah, please
Yes,
proceed.
Yes, sir. Sir, first I can ask the party to produce the Jamabandi documents of the particular property.
Why? What for?
Sir, in order to understand that whether the person is in actual possession of that particular property or not, like it is in his name or not, sir. Then, if that documents has been produced, and after reading the record of the case, if it appears to the court that the relief should be given to the plaintiff, then, sir, application of temporary injunction is to be decided, sir.
What is the importance of revenue record in this case, copy of Jamabandi? What is the relevancy thereof? Is there any relevancy with respect there to? One is to identify the land, and you may say that
Yes, sir.
Parties has corroborated is leading with respect to the description of the land. What else is? Is other, you may say that factor which will help you?
Sir, the main requirement of Order 39 Rule 1 is that whether the property was in the possession of that particular plaintiff or not.
Okay. If it is in his possession, and other party disputed, what position of law you would apply? if a party has been shown recorded in the ownership as well as the column of possession,
Yes, sir.
column possession, other party disputes it.
Yes, sir.
Other party, let's presume that you have issued the notice and not passed an interim injunction order, and after that, other party has also put in appearance, and he
Yes, sir.
disputes your correctness of the that those entries.
Yes, sir.
How which provision of law will help you in deciding the premise effect? Have you gone through HP Land Revenue Act?
Aspirant.
Land Revenue Act, HP Himachal
No.
Pradesh Land Revenue.
No,
No,
sorry, sir. Sorry, sir. I haven't read it yet.
you being from Himachal, you are required to go through it.
Yes, sir. I will read it, sir.
Section 45,
Yes, sir.
probably Section 45 of HP Land Revenue Act
Yes, sir.
attaches rebuttable presumption of truth to the latest entries incorporated in the Revenue Code.
Okay, sir.
I'm giving you the answer.
Thank you, sir.
Okay. So
Yes,
these are the, since you are coming to, you are appearing for the post, which is in Himachal, and local laws are applicable. So if
yes, sir.
you have not gone through it, it is almost paramateria with the Punjab Land Revenue Act. Have you read it? Have you read it or
No,
not?
no,
When
sir. I
Punjab
haven't.
Land,
No,
it was
sir.
not in your syllabus. Okay. So I will advise you to go through the local laws.
Yes, sir.
Have you read the have you gone through the HP Urban Rent Control Act?
Yes, sir. I have read it, sir.
Okay. Now I am putting your question. Is there any provision in that act which enables a party to enter into some sort of, you may call it, arrangement before letting out the premises?
Yes, sir. Sir,
Hmm.
it is, sir, I'm not recalling the exact section right now,
Okay,
but
no problem.
yes, sir. But it is regarding where the premises is vacant with the landlord and he wants to let it out for the residential purpose. He may seek the permission of the collector that he wants to let it out to a
Controller,
another. Yes, sir.
rent control,
Rent
not
controller, sir.
collector, but rent control.
Yes, sir. Rent controller. That he wants to let it out to some other person for a limited period of time. Then an arrangement can be made between these two, landlord and the tenant. And when the time period is completed as per the agreement, it has to be vacated by the tenant. And if he's not vacating, then the help of the rent controller can be taken.
I will, also give you clarification with respect to your proof. Exact section is section 17 thereof.
Yes, sir.
It speaks of an agreement between the landlord and the tenant.
Yes.
Whatever terms and conditions you decide, those are incorporated.
Yes, sir.
And after the termination, after the expiration of the stipulated period contained therein,
Yes, sir.
if the tenant does not vacate the premises, that order will work as order for capital offenses.
Yes, sir.
So as far as these SP local laws, you being from Himachal, you are required to know these provisions. Because there are a lot of cases not here at Dharamshala or Mandi or other towns. There are maximum cases of urban rent control action law.
Okay, sir.
Yeah. Now let's come to the criminal side. You must have gone through the basic provision of confession.
Yes, sir.
Perhaps section 24, perhaps it starts.
Yes.
What are the exceptions there too?
Exceptions.
What I mean, if you are dealing with a case
Yes.
has come before you as a magistrate, and prosecution and police has relied upon the confession of the accused,
Yes.
to prove that he has done this offense or committed forgery or committed, theft or robbery. What safeguards you are required to take while relying on the statement allegedly made under section 27 of the Indian Evidence Act?
Yes, sir. Sir,
Okay.
sir, basic requirement of section 27 is that the statement must be made voluntarily. So magistrate has to keep check that whether the statement was made voluntarily by the accused person while he was in the custody of a police officer or not. If this because sir, the voluntariness is the
What
heartbeat.
do you mean? What do you mean by voluntarily? And how you are saying that how his voluntariness could be affected? But are there some factors which affects one's voluntariness?
Sir, if magistrate, when the accused person is brought before the magistrate, he can ask the accused directly that whether he is making the statement with his own sweet will or not.
No, no. That stage will be at the stage of the 313. Then when you will be recording the statement of the accused under section 313, when the evidence is already before you. I am asking at the stage of at the time of let's go to the next stage. At the time of arguments or at the
Yes, sir.
determination of the case, conclusion of the trial,
Yes, sir.
you have to write a judgment.
Yes, sir.
What factors you will take into consideration as to whether the confession was voluntary, as you are saying. What are those factors which you would like to take out of review, which you would like to take into consideration to rule out the possibility of those factors which could affect the voluntariness of a person?
Sir,
I will
first
go
of all,
through. Please.
yes, sir. Sir, in order to ensure the voluntariness, sir, first of all, it has to be the magistrate can ensure that the confession is made in the immediate presence of the magistrate.
No, you are coming at such. I am not asking about. I am not about judicial confession. My query is with respect to extrajudicial confession. You may
Okay, sir.
call it. You may call
Okay,
it.
sir.
It is not 164. You are recording it. Police has come to the police have. I have already put forth to you to the proposition that police have relied upon
Yes,
the
sir.
extrajudicial confession of the accused made
Yes,
during the course of the investigation and not before the magistrate.
yes, sir. Sir, even in the
What are those factors? I'm asking you a question in another sense. What are those factors which could affect the voluntariness of a person, of an accused?
sir, various
To
factors
rule
are
out the
there.
possibility. Please.
Sir, that first it is to ensure that extrajudicial confession is made to whom? That the person whom the extrajudicial confession is made, whether he is a trusted person or not, and under what circumstances the confession was made, and how reliable the person to whom that confession is made. What was the relation between the parties, and what was the requirement to make the confession? These circumstances can be taken into the consideration. Then, sir, apart from this, it is to be seen whether there is a threat, inducement, or promise was there,
Yeah.
was there while making the confession or not, or whether it was made before the police officer or not. If it is made, then it is not relevant. So all these factors can be taken into consideration while deciding that the confession is relevant or not, whether it to be admitted.
And inducement, threat, and promise.
Yes, sir.
Are you required to take into consideration as to at what this point of time these type of these inducements and etc. had been exercised upon the case? Are you required to take into consideration as to whether at the time when he was making this confession was he still under the influence thereof?
Sir, as per sir requirements given under Section 24 of Indian Evidence Act, the inducement, threat, or promise, if it is coming from an authority and it is relating to the case or guilt of the accused, and it is of temporal nature, sir, then it is not relevant confession.
So anyhow, you want to say that at the time of making confession you have to rule out the possibility of these 3-4 factors which could affect the voluntariness or free consent of the accused. Okay, okay.
Yes, sir.
What else are the exceptions to it? Let us take it. Can confession of one accused could be used against another accused? And if
Sir,
so, under what circumstances?
sir, there is a law over this particular issue. As per sir, as per Section 133 of Indian Evidence Act, it states that
No,
confession.
accomplice is a
Yes, sir.
witness. I am asking you about the.
Confession.
I am not asking you to quote directly the section of the act.
Yes, sir.
But I am asking you as to what are the requirements. What are the basic requirements? If you come to the conclusion that a confession made by the accused against his co-accused could be relied upon, is there any
Sir,
specific requirement?
yes, sir. Yes, sir.
Hmm.
Sir, general rule is that no one confess on the behalf of other person. But exception is there under Section 30 that there are certain safeguards which is given that the accused who is confessing, he is confessing in the same trial where in the immediate presence of the other accused, and other accused has the opportunity to cross-examine him, and it is regarding the same offense, and the person who is confessing, is affecting himself and also the other person.
Yeah, correct. Okay. Now, in a criminal trial, there are certain general exceptions.
Yes.
In case of a person suffering from some mental ailment, you come across a case. Here, the defense takes the plea that accused was at the relevant point of time. The accused is insane,
Yes, sir.
of unsound mind. Whether you can rely on what are the factors which you as a judge has to take into consideration to see the applicability of the particular section of the insanity, unsoundness.
Sir, the basic requirement, if a person is taking the defense of unsoundness of the mind, then it is to see whether the unsoundness of mind was at the time when there is commission of the offense or not. If
How you would interpret the word unsound mind in legal parlance?
so it is
How you would interpret? How you would explain in your words unsoundness of mind?
so unsoundness of the mind basically means legal insanity, that while commission of.
What is this is what I am asking you. What is legal insanity?
Yes,
What is legal insanity?
so while he was committing that particular crime, whether he was capable of understanding the nature and the gravity of his act or not, that whether he was committing is an offense or not. So this is legal insanity and unsoundness of mind.
Correct. Default bail. Have you heard of it?
Yes, sir.
Under this provision, it is governed.
So it is governed under Section 167 of Criminal Procedure Code.
Very correct. Whether it is indivisible right, I'm putting you the proposition.
Sir,
At the time application is filed, stipulated period has expired,
yes, sir.
and in the meantime, prosecution files the challan.
Yes, sir.
what will the position? Whether his right has been defeated, individual right has been defeated or not.
Sir, if the time period as mentioned under section 167, 90 days or 60 days time period has been expired, and the bail application has been forwarded to the magistrate, and after that, if the charge sheet is being filed, then the accused has got his right to get a default bail, and it is indefeasible right until unless he breaks the condition of the bail.
Okay, okay. If the prosecution subsequently comes with a plea, comes with an application seeking bail, seeking cancellation of bail, whether you will be competent as a magistrate?
Uh, Sir, in my humble opinion, I believe that if after the application of bail has been made to the magistrate, subsequently a charge sheet is being filed, then accused get a right of bail, and cancellation cannot be made by the magistrate until unless the condition.
But you know, earlier you had filed the earlier you had passed the order mainly on the ground that you know taking the provisions of section 167 into consideration that stipulated periods maximum stipulated period has expired. Now prosecution is coming with the application that bail be cancelled. You say that you cannot review your order. This is perhaps is it your is it your point?
Yes, sir. So my point is that if the application of bail has been filed before the charge sheet is filed, then accused get a default bail, and it is
Yeah, indivisible
it's
right.
a,
Yeah,
yes, indefeasible right. And
and
subsequently,
subsequently,
yes, subsequently, if an application is made that there should be cancellation of the bail, sir,
hmm.
if the accused person is breaking the condition of that particular bill, then
No,
it
no,
can
no,
be
no,
cancelled.
no, 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 no breaking of condition. No breaking
Okay.
of condition.
Yes, sir.
No breaking of condition. Prosecution has come up with the plea that earlier, he has been released by taking under the provision of so and so. Now we are coming with the plea that we have filed a charge sheet against the accused.
So if there are the compelling circumstances that that magistrate deems fit that he is to be again taken into the custody, then magistrate can pass an order and take the custody of the accused person, sir.
Okay. Now we are accused is tried for several offences,
Yes, sir.
more than one offence, and you find that accused has committed the offences and he is held guilty. What is the limit of punishment of offences made up of several offences?
Yes, sir. As per Section 31 of Criminal Procedure Code, where an accused person is tried at one trial for several offences, then in such a case, and if the aggregate punishment of these several punishment is exceeding the power of the punishment of the magistrate, then he can do so, and there will be no invalidity of the sentence, provided if that such a sentence should not exceed 14 years of the imprisonment, and second, that it should not be twice as
No,
the
no,
power
no.
of the magistrate.
You are not having that power. You are empowered only to and pass sentence up to 3 years
Yes,
as
sir.
a magistrate, as a magistrate, as a magistrate.
Yes, sir.
Is there any limit?
So the limit
Limit
is
of
yes, sir. Limit of sir, I cannot pass a sentence in aggregate, an aggregate sentence which is twice the power of my jurisdiction. Like sir, I cannot pass a sentence of more than 6 years in aggregate, sir.
yeah. I will again ask one more question with respect to you must have gone through the provision with respect to approver.
Yes, sir.
Under what circumstances, what are the requirements? If an accused, if the prosecution comes up with a plea that an accused wants to become a approver, what are the necessary uh, factors which you will, as a magistrate, take into consideration to allow the application or dismiss the application?
Yes. Sir, as per section 306 of Criminal Procedure Code, we yes, sir. So a person becomes an approver. He becomes a prosecution witness only in those cases where there are no sufficient evidences to convict that accused person. So if there are already sufficient evidences available with the court to decide the matter, then there is no requirement of making any accused person as an approver. And
What steps you will take? What steps you will take if you come to the conclusion, yes, that he becomes to he allowed to become approver? What steps the magistrate is required to take?
magistrate, sir, as per section 306, he will examine the that approver as a witness, and he, after taking his examination and taking his evidence, he will forward the case to the court of session or the chief judicial magistrate as required.
Okay. If subsequently he retracted from his earlier statement made, then what are the options?
Sir,
Could it
if he
Hmm.
yes, sir, if he retract,
please.
yes, sir, if he retracts his statements later on in the trial stage, then sir, then offense under section 193 of Indian Penal Code it made out, sir, for making a false statement on oath, and he can be made he may be convicted under section 193 of Indian Penal Code, and he can be tried for the offense for which he was charged with.
Okay. So that's all from my side. Bhargava,
Yes, I think Rajat sir, you may take over.
please.
Yes.
Pardon?
Vikas,
Good
thank you,
afternoon.
sir. Thank you, sir. Vikas, please tell me, why I am still not convinced. Why did you not practice? Because you have a bright career as a litigation lawyer. Because I see that you're very good with studies and you have excellent marks. So why did you not practice, and why did you choose judiciary as your first preference?
Yes, sir. Sir, actually, I have explored this option also, and I really felt that being a litigant and being an advocate is a very noble profession. But sir, in my humble opinion, it is not suited to me. The reason being that, in my opinion, a advocate does not see the parties in a neutral light. Since he is employed by his client, he will definitely favor him, and he cannot do justice in the case. On the other hand, sir, a judicial officer, he's a neutral party, and he sees both the parties in a neutral light, and he is unbiased. So he's in a better position to do justice in the case.
And I think if that is that, if you think that biasness, you should keep it aside, then you being appointed as a judge in a Madhya Pradesh High Court Madhya Pradesh jurisdiction would be more suitable, because there you would not be having any friends or family. But here there would be cases of your friends, family. Some of your friends would be even practicing in Himachal Pradesh. So that, for that reason, don't you think that you are better off in Madhya Pradesh?
Sir, I believe that since I have studied in Punjab University, Chandigarh, so most of my friends are from Punjab and Haryana state, and I do not have much connection in legal field here in Himachal. And regarding the sir home district, sir, it is the policy as far as I know in Himachal that you will not get your home district when you become a judicial officer, sir.
Okay. Can you tell me a recent Supreme Court decision on the right to privacy?
Recent, sir, it's K.S. Puttaswamy versus Union of India was in 2018, sir. It was regarding the right to privacy.
What was held in that case?
So in that case, the right to privacy was recognized as a fundamental right.
Okay. Can you tell me what is institutional reservation?
Sorry, sir, I am unable to recall this particular term right now.
What is the function of Niti Aayog, Vikas?
Sir, the Niti Aayog is the think tank of the government. The job of the Niti Aayog to frame the policies for the working of the government.
And what is the full form of Niti?
Sir, it is national. Sir, it was National Institute for Training. Sir, I'm unable to recall.
Transforming India, National Institution.
Yes, transforming India.
Okay, okay. Yes. Okay. Can you tell me what is EO instanti? EO instanti in IPC.
Sorry, sir.
EO instanti. Have you heard of this term in IPC?
No, sir. Sorry, sir. I am unable to recall this term.
Okay. If we look at the preamble of IPC, it writes General Penal Code of India instead of Indian Penal Code. Why is it so?
Sir, General Penal Code, because sir, it is not specifically giving a complete law on a particular offense. It is just giving a outline of every offense which is mentioned there in the code, sir.
Okay. Can you tell me that whether theft of electricity can be punished under IPC?
Sir, theft of electricity is not punishable in Indian Penal Code, but there is electricity act that governs that particular theft of electricity.
Okay, please tell me an offense which is punishable at all 4 stages of it.
Sir, all 4 stages. Sir, I think it can be conspiracy offense of conspiracy to commit an offense, because at the very stage when there is an agreement to commit an offense, then it is punishable.
Okay, please read upon it. Okay, my next question is, suppose A kills B to offer him before Kali Ma. Before Kali Ma, okay? Before Ma Kali, he wants to offer B, and that's for that reason he kills B. What offense did he commit?
Sir, it will depend upon the facts of the case, complete facts of the case, but it can come under the category of the murder, sir.
Don't you think it will be culpable homicide?
Yes, sir.
Don't you think it will be culpable homicide?
Sir, I think it can fall under the 4th clause of section 300, that where he is doing an act which is imminently dangerous without any reasonable cause.
Okay. Okay. Though I would not necessarily agree with you, but still. Yes. Tell me that a client appointed a lawyer, and after that he disclosed the fact that he had committed a crime. Okay?
Yes,
and then he changed his lawyer.
yes,
Whether that privilege is gone now?
sir. No, sir. So actually, it is the privilege communication as per section 126 of Indian Evidence Act, and the previous advocate is still bound by this protective communication.
Okay. Okay. How about the same case in which he had said that I am about to commit a crime and I don't want you to disclose this?
Sir, if he has about to commit the crime, then it is a duty of that particular advocate to inform the proper authorities about the commission of the crime.
Tell me, Vikas, if a person is under the expectation of death,
Yes, sir.
he makes a dying declaration,
Yes, sir.
and then he doesn't die, whether that
Yes.
dying declaration will be held to be valid?
Sir, in such a case where the person does not die, then his statement can be used for corroboration as well as contradiction.
So whether it will be a valid dying declaration or not?
So it's not a substantive piece of evidence, sir. It's just it's the circumstances that will be relevant. Only, sir.
Okay, and what is the evidentiary value of a sniffer dog's evidence? Do you know a sniffer dog?
Yes, sir.
What is the evidentiary value of that?
Sir, it is a corroborative piece of evidence, because a dog speaks through his master, and since it is a hearsay evidence, so it can be used only for corroborative piece of evidence.
Right. And can you tell me if I'm giving you an example, tell me that your friend has committed when you had gone to the house of your friend, he committed a
Yes.
theft of a phone from you. Okay, and you have no evidence thereof. You somehow, but you have seen that he has fixed CCTV cameras in his house. So
Yes.
you trespassed into his house, obtained those CCTV footage by means of, I mean, wrongful method, of course, and
Yes,
then
sir.
produced such evidence before the court. Whether such evidences obtained by any wrongful means will be held to be admissible, especially in the case of India.
Yes, sir. So in the case of the similar circumstances were raised in the case of Makraj Patodia versus R.K. Birla, where it was held that an evidence which is relevant, it remains relevant and admissible, and court is not concerned that how that particular evidence is obtained, whether it is illegally procured evidence or not.
Okay. Okay. Can you tell me that yes, what is the difference between a confession and a plea of guilt?
Sir, plea of guilt basically, so confession is basically admitting that you have committing. So it is depend upon the stages of the crimes, because at the trial stage where the person is given the option whether he wants the trial or whether he pleads guilty, and there he states that he wants to plead guilty, then this stage is known as the plea of guilt stage. And confession is, it can be made to any person, like it can be made to magistrate under section 164 statement. Further, so it can be made to any other person, extrajudicial confession. So sir,
Okay. Okay. I have a follow-up question to that. That you said that during the trial he can plead guilty, right?
yes sir, when charges are framed, yes sir.
When he'll be asked that whether he pleads guilty or not,
Yes sir.
then he can plead guilty. Okay. What about he says no, that I don't want to plead guilty, but after trial commences, he says that I want to plead guilty. Can he do so? Can the magistrate accept the guilt? I mean, plead guilty at a stage later than what is prescribed in CRPC?
Sir, in such a case, it will, yes, sir, magistrate, in my humble opinion, I believe that if the accused person is pleading guilty in while the trial is being proceeded, then the court shall record that plea of the accused person and will give the conviction as prescribed.
Okay. Okay. Over to you, Arun sir. I think I'm done with it. Sir, you're on mute.
Vikas, am I audible to you?
Yes, sir.
So, Vikas, my first question to you is that with respect to the Uniform Civil Code, like
Yes.
recently, this thing is there in the limelight. So, how you see that Uniform Civil Code will be uh, beneficial to the Hindu community?
Sir, first of all, sir, Article 44 of the Constitution of India, it gives a directive principle of, it's a basically directive principle of state policy that the state shall endeavor to provide, to ensure uniform civil code throughout the country. Sir, regarding Hindu community per se, there is already a uniform code among the Hindus that we have already made a statute in this regard. And sir, and regarding the country, sir, I think uniform civil code, if we are applying it throughout the country, it will ensure equality among all the civilians.
So, as the Muslim community is against the Uniform Civil Code, so what are their basic factors that why they are against this particular UCC?
Sir, basic factors, sir, they are there is a misconception that the Uniform Civil Code is against their right to religion. They are they are seeing it as an attack on their religion, and that's why, sir, they are protesting against Uniform Civil Code.
Okay. So, do you see that once the UCC is being implemented in India, it will be beneficial for all the religions which are there in India?
Yes, sir. So it will be beneficial.
Okay. So, please tell me any three benefits which the Muslim community will be having from this.
Sir, the first and the foremost benefit is regarding the women empowerment. Right now, sir, the Muslim male is marrying three females, and he is not four females, and he is not in a generally he is not in a position to take care of all of them. And if Uniform Civil Code is being implemented, it will do it will help in the cause of women empowerment. Yes, sir. So this is the first and foremost. Apart from it, sir, all the civilians they will be under this protective umbrella of the same set of civil personal civil rights, and it will be more we are moving more forwards towards the equality, and as everyone will be treated alike. Everyone have the right will have the right of adoption that we do not have right now in Muslim community and the Parsi community. Apart from
Okay.
this, sir, yes, sir.
Mhm.
So apart from this, sir, there will be more of it will be a step toward modernization. So I see it as a step.
Okay. So, Vikas, my next question to you is that do you understand the term functus officio?
Yes, sir.
What is the meaning of this term functus officio, and do there is any exception to this particular thing?
Sir, functious option means when a judgment has been signed by the court, then it cannot be altered again once it is signed. It becomes functious officio.
Okay. And what are the
Sir,
exceptions to this?
Sir, exception to this is first, sir, in the case of review, when judgment has been signed, even then if we are there is option of review, so it is one of exception. And sir, other is that there is for the purpose of clerical and arithmetical errors, the judgment can be altered.
So, as you stated, review is one of the option is there that the court can again reopen this
Yes, sir.
judgment. Do the review can be taken up by the court suo motu?
Uh, Sir, there must be an application in order to get the relief of review, sir.
Okay. So, because if, for example, there is a particular judgment against which one of the party had filed an appeal and the other party want to go for the review, do it is possible?
Sir, here, sir, the parties, if it will depend which one of the option has been exercised first. If the review option has been exercised, then appeal cannot be filed in that particular case till the review petition is decided. But if appeal has been filed, then review petition is not available.
So, as you are in Madhya Pradesh, you are being posted in, there in MP.
Yes, sir.
So, because MP is a Hindi state, yes.
Yes, sir.
So, with respect to the review, review को हिंदी में क्या कहेंगे?
Sir, I think it's Punarvilokan. It is known as Punarvilokan.
Okay. Uh, because as you hails from Bilaspur, please tell me any three famous things from Bilaspur district.
Sir, there are a lot of famous things here in district Bilaspur. Sir, the most famous thing is first is the Sri Naina Devi Ji temple, which is one of the Shakti Peeth. Apart from this, there is Gobind Sagar Lake, which is also very famous here. And sir, there is Bahadurpur Hill Station. It's the only place here in Bilaspur where the snow falls, sir. So these are three famous places here.
Okay. Okay. So, because as let us say that you are a judicial magistrate and you are actually a judicial magistrate.
Yes.
So, my question to you is that if a public prosecutor makes an application for the withdrawal of the prosecution,
Yes, sir.
okay, and you are the authority because without your consent, the withdrawal application will not be allowed. So, what parameters you will see before allowing that particular application of the prosecutor?
Sir, the basic requirement under Section 321 for the withdrawal from the prosecution, even Honorable Supreme Court has also mentioned in various cases that it must be in the interest of the justice. If the justice allows, if case requires that there must be withdrawal from the prosecution and it is in the interest of justice, then the court shall give his permission for the withdrawal from the prosecution.
Okay, and any other thing you will see?
Sir, I will also consider the stage at which the particular case is there. If it is in the judgment stage, and I think that there is requirement that a judgment has to be passed, and there is no compelling circumstances, then sir, I will pass the judgment.
Are you aware of any important case of Himachal Pradesh in which the prosecution is being withdrawn by the state?
Sir, as far as I know, state has permission of state is not required for the withdrawal from prosecution under Section 321. But sir, as I don't, I am unable to recall any such case right now.
So, as public prosecutor is an agent of the state, so how we can say that without the authority of the state, the PP is going to make a withdrawal applications? Do PP is competent enough to do that?
Sir, the role of public prosecutor is not merely that he's just a puppet of a state government or he's not just a mute spectator of that particular agency. The role of the public prosecutor is to do justice. Even if it appears to the public prosecutor that the accused person is not he has not committed the crime, then he has also to take the side of the accused side, sir. So the role of the public prosecutor is not to convict the accused person, but to do the justice in the case. So that's the role of public prosecutors.
Because, and if the public prosecutor had made this application, and this application is there in before your court before the charges have been framed, and you allow the application, so what will be the impact of that?
Sir, in such a scenario, the accused shall be discharged from the charges.
Okay, and if the charges are already framed and then this application is allowed?
Sir, in that case, sir, the accused shall be acquitted from the case.
Okay. So my next question to you is that once a person, there is a very common note that once a person is acquitted or convicted, he cannot be tried for the same offense. So let us say that there is a person who is a victim, and against that person, grievous hurt has been caused to him, and there is an accused against whom a case of Section 326 IPC is there. Now you carried on with the case and you convicted that person under Section 326, and subsequently that victim dies.
Yes, sir.
Now what the court is supposed to do?
Sir, as per Section 300 of Criminal Procedure Code, if such a situation arises, then court can further try him for the offense of the causing of death of that person, sir.
Okay. So is it not against the rule that once the person is convicted for an offense, he cannot be tried again?
So it's an exception to this rule, sir.
Okay. Okay. Vikas, my next question to you is that as you again, I will be saying that you hails from Bilaspur. तो बिलासपुर की धाम में आपकी क्या खासियत? बिलासपुर की धाम.
Sir, first of all, I would say it's about the dishes that we made here in Bilaspur. And sir, if compared to other district dham, like sir in Hamirpur, it's more of sweeteners they use in the sweet dishes are there in Hamirpur. And if taste wise, sir, I really like Bilaspuri dham among others, sir.
Okay, so what is the difference in Bilaspuri dham and Hamirpuri dham?
Sir, in Hamirpur, first, sir, they will serve you the sweet dish. After that, they will serve you other dishes. And in Bilaspur, sir, in the end, they will give you, in last dish is the sweet dish, and before they give you the other dishes. So I personally like that Bilaspuri dham, sir.
So this is the only difference you see, and any other difference in the cooking methods?
Sir, cooking methods, sir, I haven't seen the preparation of the dham in other districts, sir, so I cannot compare.
Oh, okay, very good.
Vikas, just tell me any three famous international fairs of Himachal Pradesh.
Fair Fox. Okay.
Fairs, मेला जो
Fairs.
लगता है.
Okay,
Yes.
sir. Sir, there is there is a state level fair that
I'm
is
talking about international fairs.
international fairs. The international, sorry, sir, I'm unable to recall international fairs.
Okay. Okay. As there is a bordering district that is District Mandi, which fair of District Mandi is very famous? Are you aware of that?
Sir. Sorry, sir, I'm unable to recall.
Okay.
So
So
Mandi ki Mandi ki Shivratri is very famous, sir. So is there any fair at the time? So,
yes, it is also an international fair. Okay, so
okay,
you are supposed to know these basic things.
yes,
Anyhow, now let us come to the feedback point, and firstly I will ask Savyal sir that he will be sharing feedback with you, and thereafter we will be sharing.
okay, sir.
So, because I have got nothing special to say, make corporation well, appear boldly, and if answer, I will repeat it. If the question is put to you in Hindi, give the answer in Hindi. Use the language which is the interview. So, all the best.
Thank you, sir.
Rajat, you may please proceed.
Because I
Yes.
think the expectation of the panel would be a much higher from you. You just have to get the fact, because you have cleared the judiciary exam once. So
Yes.
they would put you questions, they would put you uncomfortable questions, and they would try to grill you. So I believe that you have to prepare your CV thoroughly first. Any questions that can come from the CV, those will be your introductory answers. So prepare your CV thoroughly, starting from
Yes.
your university, name of your university, the history, or the state, the district, the governor, law minister, chief minister, all important elements or things about your state. All of it will be asked. Then questions can be asked. If I had time, I would have also wanted to know about the experience that you have gained during this 1 month. What is your experience? That is a question that will be answered, because you'll be appearing it probably this month, HP Judiciary
Yes.
interview. Then yes, 2 months will be into it, 2 months into training. What have you learned?
Yes.
Okay, so that can be a question as well. So I believe that if you nail your introductory part of the interview, then probably you'll be in a better safe space. Because I think if you don't do that properly, then if they go to the law paper, then expect deeper questions, because you have already cleared it. It's not like you are a novice. So they would not be dealing you any lightly. They'd be
Yes.
throwing all the questions that they can. So I suggest that you revise once again all the core subjects. And like sir put question from the revenue or rent control, all of that also you should be thorough about it. Okay.
Yes.
So make sure that I have no problem with your the way you appear the interview, except the fact that you don't smile often.
Yes.
I would like to see, because you have a pleasant personality, so I don't see a problem in you just carrying that light smile. No, don't like laugh or anything, but just I'm saying
Yes,
that
sir.
if you carry a pleasant personality, then it'll be good, because you have a good personality. Show that off, show that smile. Okay,
Okay.
wear that smile, and it also makes you look more confident, if not anything. Okay.
Yes.
Because unnecessarily, I don't see that you are tensed, but it looks like you are tensed all the time. So just try to dodge that. Okay.
Yes.
Other than
Okay,
that, I think you have cracked the code once. There is no reason why you can't crack the code twice.
Okay, sir. Thank you, sir.
Thank you.
Yes, Arun sir is on mute. So you're on mute. Yeah.
Yes, because as far as the feedback is concerned, I believe that with respect to the question which I had audible.
Yes. Yes, sir.
Okay. And as Sir has stated certain questions to you from Land Revenue and HP Rent Control Act. So
Yes.
because land revenue is yes not in your syllabus and you are not that much well versed with that particular law, so it might be creating an excuse that okay you are not aware, and whenever you will be there in training you will be getting to have the knowledge of that. But yes, with respect to the rent control, you are not supposed to make any bluff, है ना? So वो आपने पढ़ा भी है, syllabus में भी है, so you must be able to crack it. उसमें
Yes.
रेंट कंट्रोल में एक जो स्टैंडर्ड रेंट और फेयर रेंट को लेके एक इशू रहा है, उसको एक बार थोड़ा सा ध्यान में रखना सेक्शन नंबर 4 का.
Yes.
Apart from that, body language is okay, but as Rajat sir has stated, that थोड़ा सा tense माहौल लग रहा है, ठीक है?
Yes.
So have a smile on your face, है ना? तो थोड़ा सा smiling face रहता है. तो हिमाचल के बच्चा फेयर्स, इंटरनेशनल फेयर, मिंजर का मेला, शिवरात्रि का, दशहरे का, कुल्लू, ठीक है? तो इनका थोड़ा सा आपको ध्यान रखना है. ये चीजें तो यू आर सपोज टू नो, है ना?
Yes.
बिकॉज यू हेल्स फ्रॉम हिमाचल एंड यू कैन नॉट अवॉइड दीज क्वेश्चंस. नहीं तो वो कहेंगे कि आपको हिमाचल में रहते हुए भी नहीं पता, है ना?
Yes.
थोड़ा सा उसके ऊपर अभी टाइम है, सो यू मस्ट बी टेकिंग केयर ऑफ दैट. बट आई बिलीव कि आपका ज्यादातर जो इंटरव्यू रहेगा दैट विल बी मोर फ्रॉम द पर्सनल साइड. लॉ के क्वेश्चंस डेफिनेटली दे विल बी आस्किंग, बट ज्यादा आपके पर्सनल डोमेन, आपका ये जो एक्सपर्टीज है अभी बीइंग अ जज, पिछले 1 महीने में आपने क्या किया, और इसी सबसे ज्यादा एसोसिएटेड रहेगा, बिकॉज दे माइट बी ग्रेडिंग यू ऑन दैट. और हिमाचल से आप कितना एसोसिएटेड है, ठीक है? सो दैट दैट द थिंग्स व्हिच आई विल बी मेंशनिंग. बाकी रेस्ट आपको कोई और पूछना है किसी चीज से तो आप पूछ सकते हैं, इफ यू वांट टू आस्क एनीथिंग.
No, sir. I just took care to give the interviews.
Thank you so much, Vikash. Thank you, Rajat sir.
Okay. Thank you, sir.
Thank
Thank you.
you, thank you,
Thank
thank you,
you,
Vikas, thank you, sir.
everyone. Thank you, everyone, for your precious time and for your graceful presence. We are really honored to have our panelist. And all the best, Vikas.
Thank you, ma'am.
All the best, Vikas.
Thank you, sir.